This afternoon, an appeals court has temporarily lifted the gag order on Donald Trump and his attorneys in the $250 million civil fraud trial against the ex-president here in New York. Filed just a short time ago, appeals court judge David Friedman temporarily lifted the order, allowing Trump, for now, to talk freely about the judge in this case, as well as his court staff, whom Trump had previously targeted on social media. This ruling follows arguments by Trump's lawyers that the gag order had infringed on the ex-president's right to free speech. We are back with David and Andrew. Were you surprised by this?
You know, I'm not, in that it seems so much like what happened in the D.C. circuit, meaning the defendant here, Donald Trump in D.C., he said the gag order was improper and I'm appealing it. And what the appellate court said is, OK, during the appeal, we're going to put things on hold and keep the status quo, and then we'll hear your arguments. That is essentially exactly what's happening at the state court level. The only reason it's a little bit more surprising is that the state court gag order is so limited. I mean, this is a gag order that basically says don't take a sharp pencil and stick it in your ear. I mean, this is, you know what? Here's how I'm abridging your free speech. Do not threaten the law clerk of the judge. I mean, that seems like it shouldn't have to be said. So that's the only part that's a little surprising. Yes, it was said that at first was Donald Trump, don't do it. Then it was to the lawyers, don't do it. No lawyer in their right mind thinks that's a good strategy if you're trying to get the judge to be on your side. Usually not a great thing to say, let me just attack your law clerk. And it really doesn't abridge in any way his ability to run for office, because as I've often said, you can actually run for office of the presidency of the United States and not obstruct justice or threaten violence with respect to the judge's law clerk.
The pause, though, is temporary. So what type of timeline, then, are we looking at?
November 27th. So we do have from the judge's order, there's a timeline for when papers have to be submitted, and there is a motion date. So that's about...
What day are we?
11 days, I think. I never do math in public, but I think that's 11 days.
Smart man. I have my abacus readily available to do the math for you. Given what you know about Donald Trump, the fact that he has 11 days of this temporary relief, what's he going to do during it?
Well, we could look at what I think is funny you should ask, because I would assume that, like, as we're sitting here, he's like figuring out what he's going to do, because I mean he's going to take advantage of it. We saw that exact thing happened in D.C. As soon as there was that temporary stay of the gag order, he started truth socialing and posting.
Here's the thing, David Jolly, especially given what we were just talking about vis-a-vis Paul Pelosi and incendiary language and rhetoric, and the fact that you can draw a direct line from that rhetoric to political violence in the real world. We know you got 11 days where he's not even going to have the whatever fear he does have of a gag order. He'll go back to attacking the judge, most likely. The impact that has not just on Judge Engoron and his law clerk, but also on future jurors, on future witnesses, on the institution of the judicial body.
Yeah, Alicia, that's right. And first of all, not to be overlooked in that first segment, Andrew Weissman said your legal analysis was exactly right. I mean, that's worth updating, like your Twitter profile or your Threads profile. By the way, I did catch that, so congratulations. Look, to your point, and I think one of the reasons is Andrew's analysis always is perfect. The appellate judge said, look, we have to balance Donald Trump's free speech versus whether or not it's actually interfering with this case. This is a civil case where there's not a jury. The language has not been around tampering or trying to intimidate a jury or affect an outcome. It's really been about complaining about the judge's staff, which is a stupid move. But is that really intimidation? Who knows? But stick with the childish theme from our previous segment as well. Who does that? Like, who actually does that? Not only is it not in your own legal interest, but what grown adult goes online and complains about a clerk or tries to insult the people in a judicial forum that can affect the outcome of the judgment, the final judgment against them? It's a stupid move.
But you know the answer to that, David Jolly, right? I mean, I think that we agree on the answer, which is that aside from all of the adjectives I could use for the type of person that does that, it is a person who believes it is politically important for him to muddy the
right.
waters, to claim victimhood, and to undermine all of the institutions that have upheld this country and this democracy since its founding.
That's right. To destroy the credibility of the forum that is ultimately designed by our founders to hold him accountable, to kneecap the judicial branch who ultimately has to make a judgment about him. But I do think to your real point, it also is somebody that's willing to accept violence in the country if they benefit from it, either personally or politically. And what I mean by that, this is a civil case in New York about money. Play this out, though, in the Jack Smith trial or in the Georgia trial, where the president's own liberty is actually on the line. His own freedom is on the line. What we know from what we continue to see is that the leap to either jury intimidation or, frankly, a call to arms from either a lone actor or a political movement that says we are going to now interfere with the forum. We are now going to interfere with the courtroom. We are now going to interfere with the judge or with the jury. It's us right back into the Paul Pelosi situation. This is why he is not fit to lead. He should not return to the White House. The fact that he was there in the first place is a shameful mark on U.S. history.
I'm going to ask a question. You could tell me if the premise of this is completely off, which is you have this motion for mistrial. You have this appeal. Do they have any relationship to one another?
In some ways, but I mean, you have to remember each court is going to be looking at the particular facts of their case and the law that's relevant to those facts. So I think that there's a relationship of the two gag orders in terms of intimidation, in terms of witness tampering, and in terms of looking at this as whether it's speculative or whether there is, as Frank Figliuzzi said, a track record. So I think that part is the same. But I think that there's separate facts that will be raised by both. I just did want to comment on one thing, which is in Georgia, the bail conditions for Donald Trump and all of the 19 defendants there is that you cannot intimidate witnesses. And there, in fact, is a pending motion that was brought with respect to one of the defendants, Mr. Floyd, for that the exact ground. It will be really interesting to see whether Fani Willis looks at all of this that's going on, looks at what Donald Trump does now, to your point, which is he may be thinking, oh, there's now no gag order in New York. There's no gag order, at least for the moment, in D.C. Depending on what he says, if he does things, and my view is he's actually already done things that are just like Mr. Floyd in Georgia, is whether Fani Willis brings the same motion, which is to have his bail revoked.